So I got more common legal myths for you today. These first three come from some videos of Merbies where he is pretty much, exposing his idiocy again. So the first one is a federal affidavit must be notarized. So he's saying, first of all, that, affidavits require a notarized signature. So, or I should say, are notarized, right, by a notary. So I'm pulling up the affidavit of Benjamin Wish in Chili's case, and I don't see, hmm, I don't see a notary's certification. So that's weird. Why is that? Could it be because Benjamin doesn't know what an affidavit is, or could it be because Merbies doesn't know? So if we refer to this thing called 28 USC Section 1746, unsworn declarations under penalty of perjury. So in federal civil procedure, an affidavit, unless it says specifically that it needs to be done by a notary public, does not need to be notarized. All it has to do is be made under attestation against perjury. So yeah, Merbies is an idiot on that one, and probably the rest of them, right? But let's go through them. So a notary can't acknowledge the signature for an anonymous party. So that's not true. Like, I'm not a notary, and you should probably talk to one, Merbies, but they're only required to well, so first of all, there's so many different types of notary services, right? So typically you say, I want an oath, which is them swearing like to a higher power. You want an affirmation where they're signing under penalty of perjury, or an acknowledgement where they're verifying that the identity of the person signing it and that they actually signed the document. And then there's a combination of those, right? So if you're asking for acknowledgement that they're making sure the person signed it, the person can sign it however they want. So like John Doe could, so I should say John Rietveld goes to the notary's office and says, I want to sign this as John Doe. Notary looks at John's driver's license. John Rietveld signs it John Doe. And then notary can't tell them how to sign their name. John Rietveld's name is going to be signed into the notary's journal, not John Doe. And he should probably sign it the same way he signed the document as John Doe. But that really doesn't protect the anonymity anyway. So that's probably not going to do it. So you should talk to a notary. But how I understand it would be done would be they would sign it John Doe, and then there'd be a third page that has the certification from the notary with the acknowledgement. And that third page would be filed under seal. So that's how you do it. So it's not true. A notary can acknowledge a signature for an anonymous party. All right, so affidavit of a dead person is admissible and hearsay. So, Todd was saying, if I'm dead, whatever, what happens? And I pointed out, well, you can still use his affidavit. So, Merbeast says, well, that's not true because if you look at the federal rules, and you're not reading it correctly, and you don't have an annotated version, and you skip relevant parts, that's not the case. So, first of all, Murby says, well, the testimony that Todd gave that was against Chile would also be valid then. So you're confirming then that the other side had a chance to cross-examine them, which is exception, right, 804B1B. You also skipped over this one, a reasonable person making a statement that's contrary to their interest, and 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 that would expose them to civil or criminal liability. That one counts as well. And then there is, if you actually have an annotated version of the rules, and you scroll down, and you look at death, illness, or infirmity, there's a slew of cases. A lot of them do talk about deathbed, and as also the other side having an opportunity to cross-examine, which we've already said that Kate's team has had a chance to cross-examine them. But there are also plenty of exceptions that don't cover that. So it's pretty much true that you definitely can use. So it would not be an admissible hearsay. All right. So then other people, because there was money collected to get cops have duties or whatever out of jail, people were saying, well, you donated all this money. What's going to happen when he gets that money back from the bail bondsman? Who's that going to go to? Is he just going to pocket it? So I have the myth as when you pay a bail bondsman 10%, you get the money back. So no. So in most states, even if you win the case, you're not getting that 10% back, and that's just goes to the bail bondsman for loaning the other 90% of the bail to you. In some states where they don't have bail bondsmen, where the state basically provides that 90% bond to you, if you win, sometimes you can get a portion of that money back. But was they in Texas? I forget, or Las Vegas, Nevada, whatever. I don't know. I think that state has bail bondsman, so he's not going to get it back. So that's all I got for you today. Merbeast, stay in your lane. Try and get your boss, forget his name, that the law firm you work at, to pay for LexisNexis or Westlaw, so that you don't just sound stupid in your videos. Mr. Homophobic first year law student attorney.